And you come back to Switzerland, and then you hear these suggestions by really colleagues that I respect, where they basically say, maybe we should give a certain kind of space for Muslim laws. And the thing is, for me, with all due respect, we're talking here about religious laws, and religious laws that were promulgated between the 7th and 10th century. These are laws that were shaped during a historical period, where slavery was an accepted institution, where women were not considered as equal. In fact, they were considered as minors in perpetual need of guardianship, male guardianship. And you come and you tell me, in the name of religious diversity, we should allow religious laws that violates the dignity and rights of women, in a context where we actually fought hard to change the laws that made guardianship, male guardianship enshrined. I had to take a stand and demand that we look closer at these laws. What are we asking for here? Because at the end of the day, what these demands will lead to is legitimatization of systematic discrimination against women and children in the name of religious freedom. In the name of religious freedom.
And of course, the proponents of these alternative courts would never say that they do that. They would say this is a way of empowering traditionally oppressed religious minorities to be able to conduct their affairs in a way that's consistent with their most deeply held beliefs, even if that bumps up against, as you say, our liberal democratic conception of the rights of women and gays and whoever else it might be who might find themselves ensnared in this parallel justice system. One place where such an experiment has been tried is in the UK. How has it gone there?
And exactly, that was the point where I realized Britain has been, with its Sharia councils and Muslim arbitration tribunals, Britain has been used as a positive example when it concerns such models. So I decided to go to the UK and research this phenomenon within its social context, because I thought, okay, I'm a researcher. Maybe the Islamic law that is being implemented in the Middle Eastern context, in the manner by which it shaped the family laws, maybe that has to do with the context of the Middle East. Look at that context within the UK, how it's being implemented. And the outcome was women in Sharia law, the impact of legal pluralism in the UK. And with all due respect, I've seen a situation, laws, because if you look at family laws, I said at the beginning of our discussion, there is an exception, and that is Tunisia. Tunisia has a family law, civil law, inspired of an enlightened kind of reading of jurisprudence, where the idea...
Why Tunisia? But I don't want to go down a total rabbit hole. Why Tunisia and not Algeria or not Egypt?
Tunisia is, in fact, a very important case because of its state formation. Look at the history of this country, and you see a state that has a long history of central authority, a long history of constitutional development. In fact, I mean, it's in the 18th century that this country inspired even the Ottoman Empire in terms of providing basic rights to its citizens. It was one of the first countries that abolished slavery. And it was a development that came from within Tunisia. And it's maybe there is also a factor that it is a country that it's not really divided in the manner that you see in Yemen. So the outcome, if you may say, of the Arab Spring in Yemen and in Tunisia, it's no surprise that Yemen disintegrated into civil war and even a collapse of its central state, whereas Tunisia is still holding, despite the difficulties. It's a very difficult situation that politically and economically the country is going through, but it stands as an example. And add to that, that when it was, the colonial control of France, if you compare how it controlled Algeria and Tunisia, you see huge differences. In Algeria, it really deliberately tried to divide the society. In Tunisia, it learned from the mistakes because it led to war. It led to huge bloodshed. In Tunisia, it learned from these mistakes and did not try to destroy the whole kind of like bases, central and administrative bases there. In fact, it built on it. And it did not try to problematize family law. So if you look at this, what happened in Tunisia, in a way, the post-colonial state came with much to start with. It has to do with the history of the country itself. It has to do with the different method of the colonial power that controlled the country for a certain period. And then you have the leadership and the vision of the president who came after independence, Bourguiba. And this president had the vision that on the one hand, we need separation between state and religion in order to have a state that is neutral to its own, to its citizens. But on the other hand, we need a different family law, a family law that changed also the social structure. Because from his perspective, the man wasn't a feminist. This is very important. What he was interested in, he was telling us, I need a modern state. A modern state needs husband and wife and 2 children, not husband and 4 wives and several, I don't know how many children. So the family law was a key tool for him to change that social structure. And when he came, there was already development from the legal perspective, Muslim legal perspective, where they came also with their own interpretation that there is nothing wrong of saying that a woman can be her own guardian.
Okay, so we have carved out Tunisia as the exception to the rule of family law dominating in these countries. So then, when you, having grown up in these cultures, these societies, these political systems, go to the UK to look at the way that it's being implemented there, what do you, for a start, just explain to people who aren't familiar with the British experiment what a Sharia court in the UK even is, or what it presides over?
You have 2 forms of application of Islamic law in the UK. The one with the first type is through what is called Sharia Councils. The numbers varies between 35 to 80, but you have really very famous councils like the one in Leyton, the other one in Birmingham. In these councils, you have self-appointed sheikhs who reside on these courts, and they decide when it comes to family affairs of Muslim couples. When it comes to the Sharia councils, the majority of those who go to these councils are women seeking divorce. Islamic law allows the husband to divorce his wife with uttering 3 words, talaq, talaq, talaq. That means divorce, divorce.
One word 3 times. Divorce, divorce, divorce. Done.
And you have a life, a marriage ending. So
I'm sure it's that easy for the women as well, right?
Yes. And on the other hand, women, either they have the right, either they can get a divorce if their husband agrees. Similarly in the Jewish law, for a woman to be able to get a divorce, she needs the get from her husband. Also that he also gives her the divorce in a get. But that only with his permission. So that's the first thing. The second thing, if she can prove harm, he hits her, he drinks, he doesn't sleep with her for 6 months, things like that, okay? Or when she gives up her financial rights written in the marriage contract. And in that case, she can get a divorce from a judge, usually. It's called Khula. The problem is basically, if you look at the type of Islamic law that is being implemented, that's why I mentioned Tunisia. Women, they go to these courts because they need a religious divorce. This has to do with the fact that some of them think from a religious point of view, they need to have a religious divorce to be really a divorce. But the main issue, in fact, has to do with the lack of registration of religious marriages. You have many studies, many surveys that showed that at least 61% of British Muslim marriages are not registered. They're done religiously. So women, when they end up, and usually the majority of them, they do not know that the British law does not recognize these marriages. You have to register it. Here in Switzerland, we have a different situation where first I have to marry a civil marriage in order for me to be able to marry a religious marriage.